Hey guys, it's Coffee. I hope you're doing well. So I have a hearing, but it's a bit long. It's like 2 hours long. So I don't know if I'm gonna break this up into one and two parts, or not. That's why I put part one with a question mark. I just don't know yet. We'll see how it goes, as we go through. I started early, way early for me. It's still like yesterday. Just because it's a little longer, than normal. So we might get through it all. We might not. Anyway, if you are not interested in watching a 2 hour stream plus, then just leave and then you can look at it tomorrow and just fast forward right to the verdict or whatever. Um, but before we get into that, though, you know, we need a little bit of foreplay. We're gonna do a quick video just to get us in the mood for court cases, and then we'll move on to the harassing hiker.
Britt Noel. Good afternoon, ma'am. I've got a few cases, 24 CR 373, the lead case, 24 M 204, 24 M 177, and 24 M 277, all trailing the CR case. In the CR case, that's the newer case, the court has reviewed the file finding probable cause. Charges have also already been filed. Ms. Stewart, did you get a copy of the new charges?
I did, Judge, and I reviewed them with Ms. Noel, but after we were done, she let me know that she did not want the public defender's representation.
No, it's not.
Okay. Ms. Noel, is that correct?
It's Noel, sir.
Oh, it's what?
Noel, Your Honor.
No.
Noel.
Noel?
Yes.
Okay, am I saying it wrong?
Yes, you're saying Noel.
Oh, Noel.
No.
Got it. Thank you for correcting me.
Yep.
Ms. Noel, is that true? You don't want a free attorney and a free
I haven't had the best,
experienced attorney to help you?
haven't had the best experience in the past. I'd like to just get immediate sentencing if I could and get this done and sent with.
When you say immediate, you'd like to plead guilty to all the charges today and be sentenced today?
Yes, just get immediate sentencing right away.
Okay.
I'm off of this, quite frankly. This is a disturbance in my everyday life.
A what?
A disturbance in my everyday life. It's
Oh, a disturbance. Okay.
not good for anybody else. I've had bad enough.
Okay. So first, I'm not going to take the plea right now. I don't think the district attorney has any offer for you even to make a plea bargain.
Okay, well, I'm not sure why I'm being held while I'm in custody to begin with. It's somebody's messing with me, so I need to get out of custody so that I can do my research and find somebody that will defend me, unless I'm going to defend myself. I can't do anything from in here.
Okay.
Judge, her other matters are open to Ms. Engelman at this time. If we
So
want to set
that's
this
what
for...
here's what I'm going to do. Ms. Engelman is the public defender who's been representing you on the other cases.
In the past, she had, yes, sir.
So I'm going to let her talk to you. If you want her to come off your case, she will file something, and I will take her and the public defender off all your cases. I just don't want to do that today. I want you to talk to Ms. Engelman before we do that.
Is there any possibility we can do that in an out of custody setting?
Yes, if you were to post bond, then absolutely we could do that.
I have no means of posting bond, Your
So
Honor.
here's what we're going to do today. Did you get a copy of the complaint? You said
Yes,
you
Judge.
reviewed it. I'm going to set this case for a preliminary hearing, March 25. Or do you want the 28th?
28th, please.
I'd like to point out that my last name is also spelled incorrectly here on this paperwork today.
Thank you. March 28th, 9 a.m. Division 7, preliminary hearing in 373. The misdemeanor cases, same date and time, 28th to 9 a.m. By the way, in case 24M204 and 24M177, I'm going to vacate the first appearance, because those are just summons cases. Vacate the first appearance and set both of those cases March 28, 9 a.m., trailing. And finally, 24M277, also vacating the first appearance, March 28, 9 a.m., Division 7. All four cases. Ms. Engelman is going to come talk to you. I'm not modifying the bond to a PR bond in the newer case. Ms. Engelman will talk to you. If you want her off your case, you want to fire her and find somebody else, you're welcome to do
I don't
that.
want to fire anybody.
I just want to tell you, she's a very good attorney.
And under what
Think about
regards won't you be releasing it to a PR bond today?
I'm sorry, say it again?
Am I allowed to ask you as to why you won't be giving me a PR bond today?
Yes, it's not appropriate given the accumulation of criminal charges in the case. as well as criminal history. It's not appropriate for
Yeah,
PR.
we'll be going ass to ass on this one, sir. And can you fix my paperwork?
I'm going to cut you off because I didn't hear what you said, and I don't think I want to hear it. I prefer you not make things worse for yourself. So I'm going to just pause with the case right now and actually end the case for today. Let's move on to the next case.
I wish I could do that in my job. I wish I could just mute people and say, you know what, I'm just going to mute you because I just don't want to hear anymore. Like, when people tell me they don't like the kind of root beer my restaurant has. Come on. Like I have anything to do with that. Oh my gosh. Yeah, I flagged somebody the other day. He came in, he's a regular. He walks in the door and he usually gets an IPA and a shot of whiskey. That's every time he comes in. Same two drinks, an IPA and a shot of whiskey. So he walks in the door and he's like, and I'm like, hey, how are you? You want your normal? He said the word yes to me. That's the only thing I heard him say. So I got him his normal drinks and I put it in front of him and then I started talking to him and I knew right then and there this guy was dead drunk, like dead drunk. And I was like, oh no. Oh no, this is not good. So, I sort of, when he wasn't looking, I took the whiskey away and I took it off his bill and I put a water there. And he's like, hey, can I get another whiskey? And I'm like, hey, how's the weather out there? I mean, he was drunk, so it was so easy to distract him. But he kept asking me for more drinks. And I told everybody in the restaurant, don't serve him. Do not serve him any alcohol. Got him a pretzel. We have these humongous pretzels. Called his girlfriend. I thought he was never coming back again because I flagged him. I hate flagging people. He came in. He came in 2 days ago and he's like, hey, I've been 15 days sober since you flagged me. Wow. I said, that's great. I didn't think you were ever going to come back in here then. And then he left me this huge fat tip. So, this judge muted him. I wish I could mute some people. Maybe they'd be happy in the end. Hey, maybe since you muted me, I realized I shouldn't be saying things like that because it's rude. All right, listen. Hi, Casey. All right, listen. I got to start this because it's a 2-hour hearing. So if you're not interested in a long hearing, then just, go take a nap or something and come back at the end. Hey, Cha. Oh man, I got everybody here today. This is great. Here we go.
Given the emotional trauma that she's suffered from his actions.
I understand. You're not intimidated. Would you agree?
Sure.
Okay. And there's some dialogue that goes on, and this is not going to work out for you, as said by your wife. Do you recall that?
Yes.
Okay. So she said this is not going to work out for you. Is that right?
Okay. What context are you trying to get at?
Right here. You just heard it, right? She said that. You heard it.
Okay. I will agree. I heard that.
Okay. Okay.
I'm not going to leave it at that, though.
No, I understand. But she doesn't seem to be intimidated at that point in time either.
Because I'm in front of her.
Okay. But she doesn't seem to be intimidated. Would you agree?
No. I would not agree.
Okay. Did she run away?
No.
Did she say, we got to get out of here? It's Becker. He's going to hurt me?
No. I was there.
All right.
I was a buffer there.
All right.
That doesn't mean her hands weren't shaking. That doesn't mean her emotional countenance wasn't impacted by his presence and his filming, which I'm sure you've heard multiple times here before.
Well, but at least to the naked eye, you're not intimidated, and it doesn't seem that she's intimidated either. Would you agree?
Objection,
No.
Your Honor, asked and answered.
I'm
The objection
intimidated by
is
the word naked.
sustained. We can
All right.
move on to something else. Mr. Kane.
Okay. You'd agree that this is a public trail,
I agree.
and the Beckers have equal rights to go up and down that trail as you and your wife do. Agreed?
Agreed.
Okay. And you're aware that it's perfectly lawful for people to take pictures of others when they're out in the public arena. Agreed?
Do you think so?
No, you answer the questions.
Not in the context in which he's doing it. No, I don't believe that's lawful or appropriate.
Okay. So you think it's against the law for like you to take a picture of me walking down the street?
I don't think it's against the law, but I don't think it's appropriate for what they're doing, is what I said.
Okay. So it's not unlawful, it's just you don't think it's appropriate.
No, I don't think it's appropriate, nor in the context of the fact that there's an active lawsuit against them, that we filed against them.
Right.
Right.
And you say we filed against them. You're in on it too?
I'm her husband. Of course I'm in on it.
Okay. And well said. Well said. Now, are you, there's been a lot of push and pull leading up to your lawsuit, agreed?
Objection, Your Honor. That's a big and ambiguous question.
I don't know what that means, Mr. Kane. Why don't
Okay.
you ask a more specific question?
In leading up to the filing of your lawsuit, do you know if your wife contacted other potential witnesses about gathering evidence against the Beckers?
Are you talking about this particular action or the initial lawsuit?
The initial lawsuit.
They were one of the defendants that we were pursuing in our
Okay.
lawsuit, yes.
But were you aware of your wife ever contacting other people and asking them to help with testimony?
Yes.
And who did she contact?
Number of the people in this room.
Okay.
Red Baxter, Mickey Flowers.
All right.
Objection, Your Honor. The line of
What-
questioning doesn't appear to be relevant with Mr. Geisler's personal knowledge of what he witnessed on the trail with regard to the Beckers.
But I was interested.
Mr. Kane, why is this relevant?
I agree. It's not very relevant. I was just moving. I'll just move on.
Good. Let's go ahead and move on.
All right. Let's talk about that day when Mr. Becker apparently chased your wife down the trail. Were you there for that?
No.
Did she speak with you about that?
Yes.
What did she say?
She said that she was extremely distraught emotionally. She was in tears. She had actually wet herself because she was so afraid. And then the following aftermath related to him posting it or the news picking it up and the associated trauma, the associated humiliation with doing something that, as I understand it, Mr. Becker was not even in his rights to do.
Okay. Were you aware that Mr. Becker was trying to serve her with papers for her restraining order?
Were you aware that Mr. Becker wrote the restraining order?
Mr. Geisler, answer the question.
Please answer the question.
Okay. So
Yes, I understand that he was trying to serve her. I also understood that our attorney had taken service and that he had no right to serve her in the first place.
So he's trying to serve her with papers. Is that right?
That I felt that he had no right to serve her with, in my opinion, yes.
Fine. He was trying to serve her with papers.
Yes.
Okay. And he's got papers in one hand and his phone.
Objection, Your Honor. Mr. Geisler has no personal knowledge. He was not there and did not see what Trevor Becker was or was not doing on the trail that day.
Well, I think you opened up the door by having him talk about this incident, so the objection is overruled. You may proceed.
Okay. So he's got papers in one hand, phone in the other. Got to be that way, doesn't it?
Sure.
All right. So he hasn't drawn a pistol or anything like that. He's just trying to hand her papers.
Okay.
Okay. Have you ever seen Mr. Becker pull his pistol from its holster?
No. I cannot think of a time I've seen him at the incline without it, though.
Understood, but he's never pulled it from its holster.
No. You don't need to pull your gun from your holster to demonstrate and intimidate.
I understand. And you already told the judge in direct questions from the judge, you didn't see him banish anything because he came down and his coat was up and over his pistol so you could see it, but he didn't pick it up with his hand. Is that right?
That is correct.
Okay. That's all I have.
Redirect, Mr. Mitchell.
Yes, Your Honor, briefly.
We'll get to it.
Mr. Geisler, please clarify what you meant when you said that you are in on this lawsuit.
I'm helping pay for it.
Thank you. Were you present on the day that Trevor attempted to serve your wife with papers on the trail?
No,
Was that the same day that Trevor walked by and lifted his coat, revealing a gun?
no,
Did you have personal knowledge of the day that Trevor walked by and lifted his coat, revealing a gun?
I'm going to object
Yes.
to the form of the question, Judge. It's contrary to the evidence before.
So why don't you rephrase the question?
Certainly, Your Honor. In your affidavit, you testified about a particular event you saw involving your wife and Mr. Becker, correct?
correct.
Please clarify what exactly you saw that day on the trail.
I saw Trevor Becker filming us at the base of the incline, as was shown here on the video. I saw Trevor Becker filming us at approximately stair 200 or 300. And I saw Trevor Becker filming us on his way down when we were descending the incline, at which point his gun was visible.
Was his gun visible at the base of the mountain?
No, it was not.
Thank you. No further questions, Your Honor.
All right, anything else of this witness?
No, Your Honor.
So you can go ahead and step down, and you are free to remain in the courtroom at this point if you wish. Mr. Mitchell, anything else?
Yes, Your Honor. Plaintiff calls its final witness, Mr. Fred Baxter, who I believe is sequestered outside.
All right. Sir, if you would step up here in front of me, please, I will administer the oath to you. Do you swear on your penalty of perjury that the evidence you shall give in the case now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? I do. Please have a seat.
Good afternoon, Mr. Baxter.
Hello,
Please state your name and spell your last name for the record.
Fred Baxter, Baxter.
What is your relationship to the plaintiff in this case, Chastity Geisler?
I've known her for about 6 or 7 years, basically from climbing mountains and the incline.
And how do you know Trevor and Holly Becker, the defendants in this action?
Just on social media is where I first heard about them. And then Trevor asked me to do a podcast interview with them. And that's basically all I know about them.
Would you please describe any interactions that you may have witnessed between Chastity Geisler and Trevor Becker at or near the Manitou Incline Trail?
Yes. On October 3rd, Chastity and I were descending at about step 2300, and Chastity was behind me, and I looked off to the side and I saw Trevor standing back into the trees with his camera pointed at us, basically more at Chastity. And October 11th, same thing happened probably at step 200 or 300. And Trevor was hiding on the side again, filming us, and it upset Chastity quite a bit to where she didn't want to do another one. And then on November 18th, probably at around same place, I think it was, we saw Trevor coming up with another individual. I don't think he was filming at that time. He didn't say anything, but once we got down to Ruxton in front of his residence, his wife was out with her camera filming us out on the street. And that's when I gave Chastity a ride back down. And then on January 18th was probably one of the worst episodes, where we were at about descending at about 1,000, step 1,000. And I see someone coming up, and I didn't realize who it was until I got right next to him, because he had a hood on and everything. And it was Trevor going up. And Chastity had stopped on the side of the trail for a moment. And so she was a couple of hundred tides behind me. And as I turned around to see where she was, Trevor was nowhere to be seen. And Chastity was hysterical coming down, and I see Trevor coming out of the trees, and he walked up a ways with his camera pointed probably back at us filming. And when we got down to the bottom, Chastity was hyperventilating and crying and picking up her stuff because we were going to do a double and she wasn't going to do it. And I eventually talked her into it. And about that time, Trevor comes running down in front of us and just went down. And there was many more episodes, but none that I documented.
This most recent episode that you just articulated, you said January. Was that 2024?
2024, yes.
In the prior instances that you articulated in October, November, was that at 2023?
23, yes.
Thank you. And Mr. Baxter, what actions, if any, have you taken to help Chastity Geisler continue training at the Manitou Incline?
Well, I encouraged her to come back for one thing, but in order to do that, we kind of look at our schedules and I'll pick her up down at the parking lot in Manitou and we'll ride together and then I'll give her a ride back unless she's doing more than I am. But we usually do doubles and we just coordinate our schedules and I go up and down with her.
And why do you take these measures to coordinate schedules with her and hike with her?
Because I fear for her safety.
Why?
Well, one incident that happened that really bothered me was quite a while ago. But so Trevor was down at the bottom of the incline doing some maintenance work or something, and the guy I was with noticed he was carrying carrying a gun, and my friend asked why he was doing that. He said there was a lot of crazy things going on the incline these days.
Thank you, Mr. Baxter. No further questions, Your Honor.
Gonna need the October 11th. Kind of warming up our tech here. I'm going to show you a video.
Sure.
Here we go. Turn around and take a look. I'm going to tell you this was a video taken on October 11th. Recognize her?
Pardon me?
You recognize her?
Yes.
Okay. Wait for this net handsome devil coming down. That's you.
Yes.
Okay. What's up, Trevor? Now I'm going to tell you, sir, that video was taken by my client on October 11th, and caught you guys coming down the incline, right?
Mm-hmm.
He's off to the side, is that right?
Yes.
And is he standing straight up or is he squatted down or kneeling?
I think at that day he was standing up.
Commonly, though, he's kneeling.
Most time I think I've seen him kneeling. Yeah.
Okay, so he's down low, right?
Not laying down, but down, squatting down. Yeah.
Right. Okay. Now, you, by all appearances, are not intimidated by Mr. Becker. Is that a fair statement?
Say that again.
You are not intimidated by Mr. Becker. Is that right?
I am not. No.
Okay. And the fact that he carries a gun doesn't intimidate you either, does it?
It bothers me.
Okay, but it doesn't intimidate you.
It bothers me.
Okay. Ever seen him pull his pistol from its holster?
No.
Now, if we look at the exhibit book in front of you, exhibit 4.2.
Yes,
Okay? If you look at that, there's a circle, and it looks like there's somebody kneeling or sitting by the edge of the trail. Is that right?
yes,
Okay, can you see that?
I can see it, yes.
All right. And I'll tell you that that's been identified as Trevor Becker. Is that commonly how he presents himself on the trail?
Not really, no.
Okay? But he's, at least at this case, on October 3rd, he's sitting down and using his phone to video people coming down the trail. Agreed?
I agree, yeah.
Okay? And
Hold on, so, hold on. You're looking at 4 point, which one are you looking at?
4-2.
4.2, okay, thank you.
he doesn't have any, he's not making any gestures. He's not threatening anyone. He's just taking a video. Agreed?
At the time of this picture, yeah.
Okay. And this is a picture actually taken by Chastity and her GoPro.
Mhm.
Okay, all right. Flip the page, go to 4.3. There he is again. Kneeling down off to the side of the trail. Not very threatening body posture, is it?
Well, you're not seeing the whole thing either.
Well, I understand, but you can see his hands,
Yeah, but
okay?
maybe the picture was taken.
Well, as a matter of fact, we've got a video of this. October 6th? Sorry.
I wasn't there.
He didn't testify about October 6th.
All right, then I'll move on. Have you ever seen Holly Becker take pictures of Ms. Chastity?
Yes,
Okay. When they do that, do they speak to one another?
no,
No threats.
no.
When's the last time that you spoke personally to either Trevor or Holly?
I don't think I've ever talked to Holly. Trevor was probably, I don't know the date, but him and Holly and his son were walking up the incline. I don't know, that was probably maybe 2 weeks ago or something.
At that time, did he try to intimidate you in any way?
Well, I'm friendly to everybody on the incline, and I just happened to look up and saw a little kid, which ended up being Trevor's son.
Mhm.
And I said, good job. And I hear someone say, don't talk to my son. And I looked up and there's Trevor. That's the only thing that was said.
But you don't know who said, don't talk to my son or,
Yeah, it was Trevor.
all right.
Yeah.
But you said just good job.
To his son, yeah.
All right. Have you ever heard Trevor or Holly yell at Chastity?
No,
Okay. You ever seen any threatening conduct other than videotaping by either Holly or Trevor
no,
against Chastity?
nope.
Okay. That's all I have. Thank you.
Any redirect examination? All right, Mr. Baxter, so you can go ahead and step down. At this point, you are free to remain in the courtroom if you wish to. All right, Mr. Mitchell, you said that was your last witness, is that right?
Yes, Your Honor, I'm going to say
All
that.
right.
Time for cross.
All right, does anyone need to take a break before we hear what the Beckers have to say?
Yeah.
Anybody need a break?
I can use a break.
All right, we'll be back in 10 minutes. We'll be in recess.
All right, this is completely my fault. There are 2 breaks during this court, and I forgot to edit them out, and I just realized that now. Sorry. All right, just everybody go grab some popcorn while I try to find the next spot. But just hold on before you prosecute this guy. Hold on. They have a chance to talk too.
Pounds of trash out of
All right, that's the best I can do. Come on, Judge. Break's over. Get back to work. It is creepy. It is creepy what he does. He gives an explanation. I don't like his explanation at all, but it's an explanation.
All right, we are back in session. Mr. Kane, you may proceed.
Call Trevor Becker.
Sir, if you'd step up here in front of the witness stand, please, I will administer the oath to you. You swear to penalty of perjury that the evidence you shall give in the case now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Please have a seat. All right, Mr. Kane.
State your name for the record.
My name is Trevor Becker.
Okay. And where do you live, Mr. Becker?
I live at 450 Winter Street. It's
Got a picture for you to look at. Hang on a minute.
Your Honor, I have a quick question. Mr. Becker seems to have some papers he brought up with him on the stand. Can he just explain what those are?
Mr. Kane, what are you planning to do with those papers?
Well, they're just his notes. But if you want, I can have him give them to me.
Why don't you just turn those over? And if you need those to answer any of his questions, you need to let us, I just meant turn them over in the witness stand.
okay.
If you need to refer to those to answer a question, then you need to let us know. And then we'll talk about what we need to do next.
There we go.
Oh, thanks.
Mr. Becker, turn around and tell me what that is.
Yes, this is a Google rendering of the property around the Manitou Incline. The green hiking icon on the left side is the base of the Manitou Incline. The red icon is where Holly and I and my two kids live. It's maybe 30 seconds from the base of the incline.
There, Coach Judge.
May?
When we say the green, oh good, I'm gonna get in my own way. The green, that's the base of the trailhead, is that right?
Yeah, that's the official start of that trail.
Okay, and the red icon,
We have a pointer here.
that's your home.
That's my home with the driveway going to the street.
Okay. Oh, there we go. Big point. There you go.
Yeah, right.
That's your home.
Right here's my home, and then this is our community. This is our driveway. My neighbor's houses are right here and right here.
Okay. And for people to walk up Ruxton, they go right in front of your house, is that right?
That's correct. Ruxton is the single road that goes up to the top of the hill where we live.
Right. There's also a free bus service up to that parking lot, isn't there?
Yeah, there's a free bus service that goes from downtown, and the bus travels and drops people off right here, where then they're able to hike to the trail right there.
Okay. And you've got a hobby, don't you?
I have many, yes.
All right, well, tell
Yeah.
the court about the hobby you have concerning Incline Friends.
Right, so I joined the Incline Friends. It's a nonprofit that supports the incline, and I was recruited because my wife and I were very successful when we moved to Colorado. We started a cleanup crew, is what we called it, and we pulled about 25,000 pounds of trash out of the forest. I was able to get 50 different volunteer groups assembled. So that recruiting effort, the Incline Friends love to see that. So I became their trail maintenance director. So I help manage and maintain the trail maintenance of the incline. So I look for erosion control issues, broken stairs, graffiti, things like that. And I help eliminate that through volunteer efforts.
And that's all with the permission of, is there an owner of the incline?
It's kind of a convoluted structure, but there's a few different owners, the primary being Colorado Springs City, the Parks and Rec organization. They have a park ranger, and she goes to our meetings. I talk to her on a frequent basis. We partner with them, and every event we do is sponsored through the cities.
Okay. And how is it that you came to know Chastity Geisler?
It was probably a couple years ago. I'm fascinated with endurance athletes. I myself, I am one, and I always look to learn from others. So when we moved here in 2017, and then primarily to the base of the incline about 2019, 2020 timeframe. I started, interviewing and talking to the local athletes that would come onto the incline. So I've probably interviewed hundreds of athletes since moving here. She was one of them. Started to learn about her, her ability to hike, and she started achieving things. And that's how we communicated, was primarily around records and achievements. We like to do barbecues for people whenever they achieve big things as well. And we offered to throw a barbecue for her at one point as well. It's something that we do often for local athletes.
And that was celebrating her accomplishments on the incline?
Yeah, I don't recall when that was, but probably in the 12 to 24 month time frame ago.
Okay. Now, as far as your interaction with Ms. Geisler, she sued you, is that right?
Yes, we were served in July, I believe, of last year.
Let's go back. Let's go back to, I think it's March of 2023, this time when you were trying to serve her with papers.
That's right,
Is that
yes.
right? Now, whose papers were those?
Those belonged to Noelia Sanchez. She was the petitioner in that temporary restraining order that was approved.
All right, so they weren't yours?
Those are not my papers, no.
Okay. And describe for the, well, let's just put up a little video. We've got some pictures.
We can't see what the court sees, but I want to try to untangle this a little bit for you so that you understand. Chastity walks this trail that she does not live near. Trevor lives right beside the trail. All right? Trevor is the creepy guy who goes into the bushes and takes videos of Chastity. Okay? So, Trevor is the leader of this group that sort of maintains these trails. Chastity is one of the hikers on the trails. So she did so many miles, or she did so many steps, or she, had an achievement. He put on a barbecue for her. Okay. A different hiker completely, that's not even in these proceedings at all, sued Chastity, a no contact order against Chastity. So Trevor was trying to deliver papers from that other hiker. Okay? Well, Chastity sued Trevor in a different case than this one. And now, or Trevor sued Chastity. I can't remember. There's another case with Chastity and Trevor, and then there's this one. So there's 3 different lawsuits with other people involved. This is just like the lawyer husband and that crazy Karen. They sued the whole homeowners association. This lawsuit started out with all those people sitting in the back as Miss Baxter suing everybody, and it just landed. Throughout the court process, they narrowed it down, and now it's just Trevor left. I hope that helps.
Oop, not that one. There we go. Do you recall this time when you tried to serve her with papers?
I do, clearly, yes.
Now, were you exchanging words with her when you were trying to serve these papers?
You can see the dialogue that was word for word depicted in point E. It says, Chastity, you are being served with this El Paso County restraining order protecting Noelia Sanchez for your actions of aggravated stalking. It is your legal responsibility to accept this packet.
You said that to her?
Yes, I did say those words.
Did she hear you, or could you tell if she could hear you?
To my knowledge, to the best of my knowledge, yes, she heard.
Did she start to run away from you?
She ran away when she saw that I had the papers in my hand.
Were you threatening her in any way when you raised those papers to show her those papers?
No, I've never threatened Chastity.
Okay. And she runs away. Is that right?
She does, yes.
Your Honor, asked and answered.
The objection is overruled.
Okay. And do you chase her?
I follow her. I do chase her probably for a period of 10 seconds as we're going down the last 10 or 15 stairs. We pass the benches and we go down that hill as I say that. And then she continues to run. At that point, I stop because I said the statement.
Enough, right? Okay. What happens next?
Next, directly after that, Greg Cummings' wife walks up the hill and she indicates that she did see a female running down the hill at a high rate of speed. She didn't realize who it was though. And then Greg Cummings comes up afterward as well. And then we talk about the oddity of someone running away from being served. And then shortly after that, the Manitou Springs Police Department, they come walking up the hill and they approach me as I'm talking to Greg Cummings.
Okay, what sort of interaction did you have with Manitou PD?
That was a very surprising and uncomfortable experience. They immediately approach me and they say, "Are you Trevor?" And I say, "Yes, sir." And they say, "Where's your gun?" And I, yeah, and I explain.
You show them.
Of course, yeah.
Okay.
It's on my right hip. And they say, "What are you doing here?" And we talk about, "Oh, I was serving a woman papers and she ran away." That's when the police say, "Did you pull your gun out? Were you shooting at her? Were you chasing her with your gun and pointing it at her?" And that's where I was very surprised.
You were not doing that.
No, I would never do that.
What explanation did you offer to Manitou PD about that?
I was really glad I had the video. Once I showed them the video, they were able to calm down. I really felt like I was going to be at least detained that day. So I'm very glad that my phone captured that video because it saved me that day.
And what did the video show?
That video, I believe it's 22 seconds long, and it shows me walking up to her as she's on the stairs. You then see her turn away. She turns around, but she turns, her body turns as she's facing me so she can see me. She doesn't turn away from me. She turns towards me.
And it is at that time that you can hear on the video, "These are for you"?
That's exactly right. Yeah.
Okay.
Yeah, I think I say Chastity as I'm approaching from behind. When I say Chastity, she turns around towards me and then starts running. And then after I showed the video to the 2 or 3 Manitou Springs Police Department officers, that's when we walk back to my house and we have to wait for the El Paso County Sheriff to come as well, since they said that it's on El Paso County territory. The sheriff has to come.
Mhm.
So we have to wait for about maybe 10 minutes for the sheriff to arrive.
Okay.
Again, I show the video. They say it's pretty clear. You have papers in one hand and a phone in the other. So
Objection,
there's
Your
no
Honor.
way.
The testimony includes hearsay. It's speaking for witnesses that are not in the court.
Mr. Kane?
Well, it's actually a rendition is what he recalls being exchanged and the inquiry about threatening behavior. And the result is everybody walks away.
The objection is sustained. It is hearsay.
All right, do we have that video? Can we put that up real quick? Hang on, we're gonna put it up.
You are being served with this El Paso County restraining order protecting Noelia Sanchez for your actions of aggravated stalking. It's your legal responsibility to accept this document.
Okay, that was you.
Yes, yeah. At the end, you can see I'm slowing down. That's where I stop right there.
She's pretty fast.
So what exhibit was that you just showed?
Well, it's the chastity service It's a,
What exhibit number?
it's not an exhibit yet. I guess
Okay.
none, let's number it by ABC. I'll be A. That'll be A. And we'll just leave the thumb drive with you, Judge, if you want to review it again.
Okay, all right, go ahead.
Move to admit A.
Any objection?
No, Your Honor.
All right, exhibit A is admitted.
Okay. Now, that being said, ultimately, she does get served, is that right?
She does, yes.
But not by you.
No, that, it took 6 serve attempts to successfully serve her. That was attempt number 4.
Okay. Now, let's move on to this litigation. And first off, did Manitou PD or El Paso County Police suggest to you that a good thing for you to do would be to video any interaction you have with Chastity?
Yeah.
And Your Honor, leading.
It is leading, but I'll allow it. The objection is overruled.
Okay.
So that's the completion of the story we were talking about. That was the guidance I was given by the sheriff, because I ask what should I do in the future, and they say in order to protect yourself, you need, if you don't have a witness with you, there's a moment where I was hiking with another person I didn't record because that person was my witness. So if I don't have a witness with me, I need to step off of the trail. If possible, I need to squat down or sit on the ground so that I'm not in a threatening pose. It's actually a pretty vulnerable pose. And then I need to not make eye contact or make any type of verbal or nonverbal communication, such as gestures, and then just record as they go by, and then record as I walk away. So that's the guidance I was given. You repeat.
I don't know. Was he given that guidance to hide in a bush and record? Or was he talking about maybe if you spot a bear? I don't know. I'm trying to figure that one out.
Repeated that guidance to me, instructed me, in fact, to continue to do that. So that's what I've done anytime we come in contact with each other.
Your Honor, I object to Mr. Becker's testimony that he just provided, as it references testimony that he was allegedly provided from law enforcement, who's not here to confirm, corroborate that testimony.
Mr. Kane?
Indeed, but he was advised, and I think it's part of the explanation for why he's doing what he's doing. And so I think it's relevant, and it's not necessarily offered for the truth of the matter asserted. It's more offered for an explanation as to why he's taking that.
The objection is overruled. That is a proper use of this testimony. You may proceed.
Okay. Now, chronologically, let's show them the next video. Just show them one. Now, first off, who's taking this video?
This is a video that my wife took.
Okay, you've seen this video before.
I have, yeah. She likes, we live in the mountains, and she likes to enjoy the view. And she was on her balcony that day. And as instructed by you, when Chastity goes by, we need to record so that we have evidence of what occurred, just so that you can see that we're not threatening her.
Okay. Let this one run first.
This video, you can see that Chastity turned around, went back into view, and then lifted her GoPro and started recording Holly at our house.
Now, in that case, Chastity stopped, went back, got a better view of your home, and took a picture of you. Is that right? Or of your wife?
I would say probably a 20-second recording would be more accurate than a picture.
All right.
Yeah.
But she took pictures of you, and you're inside your house.
That's true, yep.
Okay. Let's look at another one.
Oh, hold on. What exhibit did we just see?
I'm sorry.
What exhibit did we just see?
We're gonna have to call that one B.
Any objection to B, Mr. Mitchell?
Yes, Your Honor. Mr. Becker stated that his wife filmed it. He did not. So I don't believe that proper authentication was laid for that video.
All right, Mr. Kane, what do you want to say about that?
Well, I can either have Holly give the appropriate foundation during her testimony.
Let's do that.
Let's do that. All right, so we'll move on. See the next one.
The October 6th one.
All right, now what's this?
So in this video, I'm hiking up the incline, just getting some exercise. You can see it's early morning, so I'm just enjoying the sunrise. As instructed, I step off to the side to give distance and space. I'm squatting on the ground so that I can't, appear threatening or intimidating. I'm not looking at her or talking to her. I turn my camera as she passes by, immediately stand up. It's a beautiful sunrise. That's why I'm out there that morning. And then I continue hiking up. You can see I'm not communicating or anything. I'm just continuing on my way.
And did you turn around at some point in time? Did you make it to the top or did you have to turn around short?
We can check that GPS app, Strava. I believe that I hiked to the top. That was my intention that day.
Okay. So when she was going down, did you see her coming back up?
I don't recall. That does happen though. That's a curious thing. Sometimes she chooses to turn around and continue hiking knowing that I'm there.
Do you do laps?
I do, yeah. I did a triple this Saturday.
Commonly, do you do laps or just one up and one down?
I would say I typically enjoy doing partial laps. I like to go down the Northern Return Trail. That's a trail that the nonprofit I'm a part of fully funded and paid for. So that's something that a lot of maintenance events occur on. So I like to get an eye on how that trail's doing. Also, I have time restrictions. I can't hike a lot. I have a lot of obligations in my career. So sometimes I only have 30 minutes. So if that's the case, I can get a quick exercise in by going to the halfway point and coming down.
And since this litigation was filed, I presume you always hike with your phone.
Yeah, I do with the
And
phone.
you always have your pistol, is that right?
I have consistently carried for the last couple of years, yes.
All right. And we've heard a lot about this sweatshirt deal. Did you at any time lift your sweatshirt up to show the plaintiff your pistol?
No, I would never do that. I would never intentionally brandish a weapon in a threatening manner.
The explanation then would be that you were coming down the steps and your shirt got caught up behind the pistol in the holster.
Objection, Your Honor.
That, Mr. Kane, that's really leading over the edge.
Okay.
The objection is sustained.
Can you offer an explanation as to why your pistol was suddenly visible?
I would say if that situation did in fact occur, it wasn't intentional. I am trail running down a mountain, down the incline, and I had a sweatshirt on. So if you're running, sometimes it rides up. That does happen. Sometimes you lift your arms up and you get exposed, so you have to readjust your outerwear. Anybody who conceal carries recognizes that as a commonality.
All right. Now, have you ever pulled your pistol, unholstered it while on the Manitou incline?
No, I have never done that.
Okay. Have you ever threatened anyone with your pistol on the incline?
No, absolutely not. I would never threaten somebody with my firearm.
Or anywhere else?
Or anywhere else. I would never do that.
Okay.
The only time I would ever draw my firearm is if it's a legally justifiable self-defense moment and I need it to do that to protect the ones I love or people around me.
Okay. And we talked about that. Now, there's been some talk about you following the plaintiff up the trail and down the trail and all that kind of stuff. Did you ever intend to intimidate the plaintiff in any way?
No, I have no interest in intimidating anybody out on the incline. I do the opposite. I support and build up our community. I've never intimidated Chastity.
Okay. If we look at the exhibits And I think we, photos of, I think it's exhibit 5. Let me look. It's exhibit 4243. Is that book in front of you?
Yeah, one moment. C42, yes, October 3rd. Stair
Right.
2300.
Is that you in the red circle?
Yes, yeah, that's me. That's a day where, again, I was hiking. You can see it's early morning because the sun's at the horizon. Just out there hiking the trail seconds from my house, enjoying the morning. As I'm going up, I can see that Chastity is coming down. And as advised by you and the sheriff, so I step to the side, squat, and I record her going by and then record myself continuing to hike beyond that.
Okay, chat, we're almost at the 1 hour mark of this stream. So I'm going to keep playing a little bit more, but tell me if I should just keep going or did you have enough and we can finish it tomorrow? Just let me know what you want.
Okay. Let's go to the next video. What do we got left? Okay, here we go. October 11th. Do you remember this one?
I do, yes.
Now there's a picture in here at, maybe there isn't. Nope, there isn't. What's your posture as she goes past you?
Well, I believe I'm squatting at this point. I think you can see me stand up. But yeah, I look forward and then I turn my camera this way as they go by. And then I exit the situation as quick as I can. I mean, there's really no other option if I'm going up the trail other than, I could turn and run, but I want to hike that day. So that's what I'm doing.
Sure. So you get off the trail, make room for them to go by.
Yeah.
Go back on and go up.
Yeah. I don't want to be shoulder to shoulder and be that close to her. So I step off to the side.
All right. And I think that'll be C. And I'd offer that at this time.
Any objection to C?
No, Your Honor.
C is admitted.
Okay. Have you ever engaged in any conduct intended to intimidate or frighten Ms. Geisler?
No, I've never done that.
Okay. How about your wife? You ever seen her do it?
No, my wife's never done anything to intimidate Chad.
Now, there's a picture in here somewhere of your wife sort of behind some bushes. Now, where's the Ute Indian Trail?
Yeah. Okay. So the Ute Indian Trail, that's a trail that runs, behind our house and pretty much parallel with the incline. And in this photo, you can see that my wife is on the trail, and then there appears to be some trees that are located in between the camera and my wife. She is not in the trees, as stated earlier.
But that's a designated walking.
This is a public trail, correct?
Okay. And that's, as far as you know, is what your wife was doing on the trail that day. She was just enjoying the outdoors.
Yeah, she does that almost on a daily basis. She walks our dogs constantly. She hikes with the kids, and she hikes on the trails.
Objection, Your Honor. The question was leading and called for an answer that was responsive to the leading question.
Those objections are overruled.
Okay. Now, were there occasions when, as you were going up the trail, that the plaintiff stopped and turned around and came back up the trail behind you?
That's happened on
Objection, Your Honor.
numerous occasions.
So what was the objection, Mr. Mitchell?
Leading, Your Honor.
The objection is overruled.
Yes, that's happened on numerous occasions where I will be hiking up, and then she will turn around at the bottom and then approach me from behind, which I feel is odd given the situation. So in those situations, I will stop, a step to the side, and I'll let her pass, and then keep distance. So if she goes at a pace slower than mine, I have to slow down because I don't want to pass her again.
Okay. Does she commonly walk this trail alone?
I don't know. I would say that I commonly see her with other hikers, such as Fred, um, and maybe other hikers too. Yeah.
Okay.
I've only seen her a handful of times on the trails. Each time though, I've recorded, and if we want to put it on the flash drive, we can do that.
Okay.
I've made it a point to ensure that every time we cross paths, I record. That way the situation cannot be exaggerated or mistold.
Okay. Now, one more. January 7th, what's left? Before we get started, let's share a little background with the court on this. What's going on January 7th?
January 7th, this was a Saturday, I believe. I started a new role in a company. I'm an executive in a couple different companies in the healthcare, construction, and rental management sectors, and it's pretty intense. So sometimes I can only hike like one day out of the week. So this was one of those days, and I'm just trying to enjoy the day. And as I'm walking up the incline, I can see and hear those two there. So I have to start recording. As I go to walk by, you know, I'm name called and conversations initiated by Jared.
Okay, let's go ahead and play it real quick.
Oh, yeah? Like what? My douchebag, what else am I? What are you trying to accomplish, Trevor? What else am I? A douchebag and what else? I mean, a douchebag once for that one. That was a good one. That's funny. That speaks so much. But that's the value. Oh, or what? You know why I have to do this? Does it make sense?
Now, this next part's important. What did you hear said? There you go.
Yeah, right there, I say, it'll pan out. Jared said, I'm sure it will. Chastity says, not for you. I then say, not for me. Jared confirms, and he says, no.
Work out for me?
No, let's get something clarified here. Were you there simply to videotape these two, or were you heading up the trail regardless?
I was just trying to hike and enjoy the afternoon or morning. I don't recall if it was earlier or later. Yeah, I just want to hike. You know, that's why we moved there. I'd prefer to not see them if that's an option.
Okay, so you weren't following them. They just happened to be there when you started your hike.
That's right. I've never followed them.
And let's call that exhibit, what are we on, D?
Yes.
Move to admit D.
Any objection to D?
No objections, Your Honor.
D is admitted.
Judge likes
Okay.
D.
We all done with the videos? I think we are. All right. So let's just go back. Have you ever intended to intimidate Ms. Geisler in any way?
No, not in any way. I would never do that.
Okay. And you never threatened her physically?
I've never threatened Chastity.
Okay. And you were advised by Manitou PD and the El Paso County Sheriff to videotape any interactions between you?
That's correct, yeah.
Okay. And that's what you were doing?
That's right. You also gave me that guidance day one.
Okay. Anything else? That's all I have, Judge.
Cross-examinations?
Yes, Your Honor. Good afternoon, Mr. Becker.
Good afternoon, Mr. Mitchell. correct?
Yes, thank you. You stated today that you always carry your pistol on the Manitou Incline Trail. Is that correct?
I am a concealed carry holder. I carry my firearm on a daily basis, yes, regardless of location, unless, we're in a situation like today where it's not legal to do so.
And are you left or right-handed?
Right-handed,
You carry your pistol on your right hip?
right hip, yes.
And so in the exhibits marked 6-1, 6-2, and 6-3, you have those in front of you. Do you see, and does that depict your pistol on your right hip?
I can't see it in 6-1. Can't see my right hip, but yeah, it's definitely going to be there. I don't think I go a day without carrying it. Yep.
And you said earlier that
Hold on a second.
Yes,
You were
sir.
asked about 6-2 and 6-3 also.
Two, that's me in 6-2, so yes, and then that's me in 6-3, so yes, sir, that's correct.
you were wearing a pistol on each of those photos.
On my right hip, yes, sir.
You stated earlier today that it's okay, you think it's okay to expose your pistol when you're overheated, when you're hot, by pulling up your jacket. Is that correct?
No, that I did not say that.
I did not say that. Did you say that you pulled it up on the day that you passed Chastity Geisler and Jared Geisler?
No, I did not say that.
Did you say that you may have pulled up your jacket?
No, sir.
Okay. What happens when you get hot and wear a hoodie and you're concealed carrying? Do you think it's okay to lift up your hoodie to relieve yourself from the heat?
Yeah, that would be perfectly fine. On that day, I did not do that. I wore my hoodie the whole day. It was cold that day.
Okay. You stated earlier that you're very busy. You have 3 jobs, correct?
I have a role that oversees numerous companies, yes.
And given the time restrictions that you have with your work, you only are able to work out on the trail and hike about 1 day a week. Is that correct?
I would say for the months of November and December, that was very true. And then for the months of January and February, the job that I'm currently in, the demand has started to taper down as I stabilize this company. I'm no longer working 80 or 100 hours a week.
You stated you have about 30 minutes or so sometimes to hike the trail.
Yeah, exactly. Sometimes I need to drop the kids off at school and I have some time, so I'll hike for a small amount of time.
So how is it that when you have such time restrictions, like 30 minutes, how is it you have time to just sit on the side of the trail and wait for Chastity to descend so you can taper?
Yeah, so if I'm going up the incline and I see that she's there, I'm not going to continue going up and be shoulder to shoulder with her. I'm going to always step to the side, and then that's when I'll do that procedure we talked about.
And how many times do you think you've done this? Where you step to the side?
I don't have the exact number, but every time has been recorded and documented, and we can provide you that data.
Would you say it's fair to say 20 times?
I don't know.
10 times?
I don't know, sir. We can provide that, though. I can show every time-stamped date.
I'd now like to talk about Exhibit D, the video we watched on October 7th. Isn't it true that...
I'm sorry, can you remind me which one is Exhibit D?
Yes, Exhibit D, October 7th, at the base of the mountain, at the base of the trail, there was a video that showed an exchange between you and Jared Geisler and Chastity Geisler. Do you recall that video?
Hold on a second. You are calling that October 7th.
It's January.
Oh, I'm sorry. I misspoke, Your Honor. Thank you.
It's January.
January 7th.
Go ahead.
With Jared present, I remember that, yes.
You stated earlier that you were instructed to wait to the side of this trail, step off when you saw Chastity, and not approach, not say anything, not make eye contact, and just hold your phone up and record. Is that correct?
That's correct, yes.
So then why on this instance did you approach them and engage with them and while recording?
So on that morning, I'm walking by to get to the base of the incline. They're about 20 feet away. In that recording, you can see the distance. And then that's when that conversation is initiated by Jared with the insult.
So why did you approach them instead of walk away from them?
Yeah, that was, I could have done better job, and just continued on. Having that conversation wasn't very productive. I agree with that.
And now I want to talk about the concealed carry permit you have. You currently have a valid concealed carry permit?
I sure do, of course.
Okay. And do you recall when you filled out the paperwork for your concealed carry permit?
I remember the process vividly, yes. Yeah, I had to go through extensive training and testing. I got a certificate, and then after that point, I had to get background checked with El Paso County Sheriffs. And then from that point, I was fingerprinted for an FBI background check. That took about 3 months. After 90 days, I was presented my certification and the license.
And isn't it true that in that paperwork you filled out, you had to indicate whether or not you've had a history of mental illness?
Correct, yes.
And how did you respond?
No, I don't have a history of hospitalization, mental illness.
I didn't say hospitalization, I just said mental illness.
Mental illness is, classified as being committed to a mental institution.
Have you ever had a history of mental illness?
Of course.
Well,
Okay.
I'm going to object to this line of questioning, Judge. I think it's irrelevant.
Oh, I'm sorry. Go ahead. Why is it relevant, Mr. Mitchell?
Yes, Your Honor. I think the question goes to the heart of the behavior. Here we're talking about behavior that in the aggregate shows intimidating, stalking, menacing behavior that normal folks on trails don't do. And I'm curious as to how a person who has been issued a CCL, concealed carry permit, who has to answer a question as to whether or not they've had a history of mental illness, was issued one when they've admitted in writing to having a history of mental illness, an exhibit I intend to use for impeachment.
What is the question on the application?
Have you had a history of mental illness?
Is that the question directed
Yes.
towards me?
I'm going to continue to object. I don't think it's relevant.
No, the objection is overruled.
Okay.
So I have had depression.
Would you please turn to what's been marked as Plaintiff's Exhibit 8, sir?
Sure.
Is that your name at the top of this document, Trevor Becker?
It is, yes.
What's the date below your name?
November 21st, 2021.
Do you recognize the person in the photo next to the name?
I do.
Who is that?
That is me.
Do you recognize this document?
Yes, I do.
What is it?
This is kind of like a summary of how I was progressing in that moment.
Isn't it true that major suicidal depression and having thoughts of harming yourself, wouldn't you consider that to be mental illness?
Judge, I'm going to object to this line of questioning. I think it's getting far afield.
No, it's might be appropriate. The objection is overruled.
Let's see. So in this, I talk about how I had been talking to a therapist in the last year. And
Let me just ask you, sir, is it a healthy for a person to have suicidal thoughts?
I think that behavior is unhealthy.
Is that a mental illness?
I don't know.
Is suicidal depression a mental illness?
I don't know. So
I feel that you answered appropriately on your petition for a concealed carry license when you said, no, I've never had a history of mental illness.
Yes.
No further questions, Your Honor.
Anything else of this witness?
Nothing.
So you go ahead and you go ahead and step down.
Thank you.
All right, Mr. Kane, anything else?
Calling Holly.
All right.
She should be brief.
Ma'am, if you'd step up here, please, I will administer the oath to you. Please raise your right hand. Do you swear under penalty of perjury that the evidence you shall give in the case now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? Please have a seat here in the witness chair.
State your name for the record.
Holly Becker.
Mary?
Yes.
To who?
Trevor Becker.
You're sitting right here.
Yes.
Okay, how long have you been married?
10
Gotta
years.
Get this right.
10
How
years.
long? Okay. And are you aware of a lawsuit that was filed against both you and your husband by Chastity Geisler?
Yes.
Okay. Now, let's show that one video real quick and get that out of the way. Hang on.
Holly, which one is it? Yeah, that one.
Let's wait for it. No. You take that video?
Yes.
Okay. And what is it? It shows, first off, she's hiking by herself, isn't she?
Yes.
And you're kind of an at-home mom now?
I'm a stay-at-home mom currently.
Okay. And so you're kind of on the lookout for what's going on around your house.
Mhm.
You commonly see Ms. Geisler heading up the trail.
Yes.
Is she alone or with friends?
Usually alone.
Okay. Now, there's another video in here showing a picture of you down on the main street of Manitou. Get it real quick.
Hold on a second. Are you going to admit, you're going to offer Exhibit B?
I'm not, I should offer the video of the wave and the exchanging of photographs.
Right, that's been marked as B.
Okay.
Any objection to B?
Foundation, Your Honor.
That objection is overruled and B is admitted.
Okay. Now let's look at this next one. You recall taking this video? Wait one.
Yes, I do.
Okay. And you took this video, is that right?
Yes.
Who's that waving?
Chastity.
Okay. How is it that you're down there on the street taking pictures of Chastity?
That is the bottom of Ruxton Avenue, which is the street that my husband and I live on.
Did you follow her down there?
No, I did not.
Okay. So you just happened to be down there and there she was, and so you took her picture?
Yes.
Objection, Your Honor, leading.
That objection is overruled. What exhibit is this, Mr. Kane?
That'll be F or G. Where are we?
Should be F.
F.
That'll be F.
Any objection to F?
No, Your Honor.
Okay. In that video, did you intend to intimidate the plaintiff in any way?
No.
Okay. In that video, does she appear to be intimidated in any way?
No, not at all.
Okay. Now there's a picture of you hiding behind some trees. You want to explain that to the judge?
I believe I don't have my notes with me, but I believe that was February 20th. I was hiking Ute Trail that day. Might have been a different day, but either way, I was hiking Ute Trail.
Look at 5-3. No, look at
Oh.
in the booklet. Yep.
Yeah. Does it say what day it is? Yes, yeah, that's me hiking on Ute Trail.
Okay. Now, are you trying to hide from anybody?
No,
What's going on?
I am walking down Ute Trail. I saw Chastity coming up the incline right next to me. So I started recording her as we passed each other. I did not stop. I kept walking and was just recording as she passed.
But you weren't, you actually like the Ute Indian Trail, is that right?
Yes, it's my favorite trail.
Okay. Now, there's some follow-up exhibits, 5-4 and 5-5. Are these pictures taken by you, or what's going on here?
I don't know where those pictures were taken from.
All right. The one shows a 5-5 shows sort of a gray-green, is it a Subaru?
Yes,
Is that your car?
yes.
Is that you driving it?
I can't tell, but I'm sure it is.
Okay. And that's you taking a picture of what?
That would be me taking a photo of either Chastity or of her car. I can't tell what I'm taking a photo of.
Okay. Now, what's the deal? Why are you taking pictures of Chastity?
I was told to the same day my husband was told to by the police department and by you.
Okay. Now, in this picture in 5-5, first off, are you following Chastity around?
No.
How is it that you're sort of going past that parking lot?
It looks like this is Manitou Avenue, which would be the main street in Manitou where I live. So I drive on that road every day.
Okay. It's the way in and out of town.
Yes.
All right. And that's why you're there.
Yes.
Have you ever stalked the plaintiff in this case?
No.
You've never followed her around trying to find out where she is and what she's doing?
I have not followed her around. I live in Manitou, so I see her walking in Manitou, walking on my street, walking by my house. I see her car parked and know that she is at the incline.
Okay. But that's just because you happen to live there and you're active in your own neighborhood.
Yes.
All right. Now let's talk about your husband. Has he ever, to your knowledge, ever pulled his pistol in anger or an attempt to intimidate anyone?
No.
Concerning the interaction with the plaintiff in this case, and you know him as well as anybody, do you have an opinion as to whether or not he would ever pull his pistol to intimidate someone?
No, he would not.
Objection, Your Honor. The question and the answer was calling for speculative testimony.
Mr. Kane.
Well, I think that she can talk about his character. She lives with him. She sleeps with him. And if it's inside his character to operate in certain circumstances, that's what he's doing.
For today, I'll allow that evidence as admissible under Rule 404. We might have to revisit that during the trial. Go ahead.
All right. Okay. As far as, is he ever, well, have you been with your husband at any time on the trail when he sees the plaintiff?
I'm pretty sure there's been some point that we have been together and seen her, but for the most part, we are not together.
Or at least hiking together.
Correct.
And that's sort of a dramatic process. You got kids at home, you got to have somebody with the kids.
Yes.
Okay. Have you ever threatened the plaintiff in this case?
No, I have not.
You ever engaged in any conduct which you intend to be threatening?
No.
Ever engaged in any conduct that, in your opinion, could be interpreted as threatening?
No.
Have you ever meant harm to the plaintiff?
No.
That's all I have.
Cross-examination.
Briefly, Your Honor.
Did you hear my phone ring?
Mrs. Becker, I'd like to direct your attention to what's been marked as exhibits 5-4 and 5-5.
Yes.
You stated you're the owner of this green Subaru.
Yes.
You stated that you were inside the vehicle taking photos or video recordings that day in what appears to be a parking lot.
I must have been. I can't really tell from these photos.
Isn't it true that this parking lot is approximately 1 mile away from your home?
Possibly. I'm not sure.
And why is it that you would be 1 mile away from your home taking photos of Chastity Geisler?
This parking lot is in the small city of Manitou Springs, and I pass by it daily to take my kids to school and to bring them back home.
Isn't it true that the parking lot's on the opposite side of the road that you use to take your kids to school?
No. There are 2 ways out of Manitou.
So you take the way that passes by the parking lot where Chastity parks her car.
I go both ways, different days.
Same.
And why did you feel the need as you were passing Chastity's parked vehicle to take a photo?
Due to this lawsuit, I'm gathering evidence of her being at the incline, which is right next to our home.
Okay. No further questions, Your Honor.
Any redirect examination?
None.
Ma'am, you can go ahead and step down.
Okay, thank you.
Any other evidence from the defense?
None.
All right, anything else? Any closing by the plaintiff?
Yes, Your Honor. Chastity Geisler, the female world record holder for the most summits of the Manitou Incline in a year, continues to train at the incline on a weekly basis. And as the court has heard today, Ms. Geisler has suffered and will continue to suffer tremendous emotional distress, including crippling fear, as she's testified, anxiety, and panic attacks from Trevor and Holly Becker's repeated harassment, stalking, intimidation, and menacing behaviors towards Mrs. Geisler at and near the Manitou Incline. The court should find that Ms. Geisler has met her burden of proof for the requested preliminary injunction. The 6 factors the court is to consider, I'll go through them each individually. Number 1, Ms. Geisler has a reasonable probability of success on the merits. Her claims against Trevor and Holly Becker are for defamation per se, intentional infliction of emotional distress, and civil conspiracy. Ms. Geisler has prevailed on all 4 dispositive motions in this action on the same claims, including the collective defendants conspiring to intentionally inflict emotional distress on Mrs. Geisler.
Well,
Yep.
hold on. What evidence do I have of that?
It's in the record, Your Honor. We have 4 dispositive motions that Ms. Geisler has prevailed on.
Okay, what's that got to do with proof on the merits?
Probability of success on the merits, Your Honor. The same claims that were made in those dispositive motions go to the facts that we're addressing today, which is intentional infliction of emotional distress, as well as civil conspiracy.
What motions are you referring to?
I'm referring to the 12B5 motions. There was 2 of them that this court denied that were filed by defendants Sanchez and by defendants Jones. And they went to the heart of the claims that we're talking about today, which is civil conspiracy, where the collective defendants conspired to intentionally inflict emotional distress on Ms. Geisler. One of those particular events for those claims was the event that we've discussed ad nauseum today about Mr. Becker serving papers on Ms. Geisler on the trail, the Manitou Trail, while armed.
Are you suggesting that the standard is the same? A 12B standard and your burden in this case?
No, Your Honor.
Then why is that important?
This standard has a reasonable probability of success on the merits. I'm saying we passed the dispositive motions, meaning there is a probable likelihood of success on the merits.
Okay. All right. So, and I can't find them quickly, so remind me. I denied the motion to dismiss under the strategic litigation SLAP case. I denied the motion to dismiss for failures to state a claim.
Correct, Your Honor. And in both of those motions to dismiss with failure to state a claim, the motion was to dismiss the claims in particular that included intentional infliction of emotional distress on Ms. Geisler by the collective defendants.
Right.
And that was under the civil conspiracy claim as well.
Right.
And you
So
found that the plausibility standard had been met.
the plausibility standard had been met.
Yes.
Today, the standard is much different. Right?
Yes, Your Honor.
Okay.
So this is just one factor for the court to consider is the reasonable probability of success on the merits. The evidence presented today only bolsters Ms. Geisler's claims against the Beckers and supplements the documentary evidence that was attached to the plaintiff's third amended complaint. The evidence printed today reflects that the Beckers have been intercepting, stalking, and harassing Ms. Geisler on and off the incline trail, waiting in the bushes to record her as she hikes by, and brandishing a firearm while walking within a few feet of her. Accordingly, Ms. Geisler has a reasonable...
Hold on a second. What do you think the word brandishing means?
I think brandishing, Your Honor, means exposing a firearm that you are carrying to someone else. I don't follow I don't accept and agree with the interpretation of defendants that brandishing means openly pulling and drawing it from a holster. I believe but brandishing is showing it with intent to someone else.
Well, now you added something there. You added with intent.
Yes, Your Honor.
Okay.
Ms. Geisler testified that the jacket that Mr. Becker was wearing was pulled up. Mr. Geisler testified to the same. For those reasons...
The testimony, I think, by Mr. Geisler was the hoodie was pulled up. He doesn't know when, other than sometime after he saw Mr. Becker earlier.
Yes, Your Honor. He did testify that it was pulled up, although he did not see him actively pull it up, whereas Ms. Geisler testified that she did see him do that.
That's quite a difference, isn't it?
Well, they both have different perspectives, Your Honor, and one might have seen something the other did not.
Yeah. So one's telling the truth and one isn't. Go ahead.
Now, for these reasons, in the aggregate, and given the multitude of evidence provided by the Geislers as well as Mr. Baxter about the Beckers continually following, filming, recording Mrs. Geisler, the plaintiff's position is she has a reasonable probability of success on her claims on the merits should this continue to trial, specifically to the intentional infliction of emotional distress and civil conspiracy. Same with Holly Becker, Your Honor. If she's going to be recording Holly Geisler 1 mile away from her home, it's only for the purpose of intimidating, harassing Ms. Geisler during this proceeding. These behaviors have only increased since the lawsuit was filed. And this is not even going to what the initial actions were that gave cause to the lawsuit, but supplement them, Your Honor. The second factor the court has to consider is that the evidence has shown that a danger of real, immediate, and irreparable injury to Ms. Geisler exists, which may be prevented by injunctive relief. Ms. Geisler trains at the Manitou Incline on a weekly basis, as she's testified. Trevor and Holly Becker also reside near the base of the incline, and thus the parties are in close proximity to each other on a weekly basis. The testimonial and documentary evidence presented today reflects that the Beckers have been intercepting, harassing, video recording, following, and stalking Ms. Geisler on and off the trail by hiding off in bushes, taking video records of her, even though there's difference in perspective and opinion on that, and also making visible a firearm that was previously concealed while walking within just a few feet of her. Any reasonable person that walks within a few feet of somebody who exposes a firearm is naturally going to have fear, especially given the context, the background information between the parties here. Ms. Geisler has suffered, Your Honor, and will continue to suffer immediate and irreparable emotional distress due to Trevor and Holly Becker's continued behaviors on and near the Manitou Incline. We've heard Ms. Geisler testify of panic attacks, anxiety, and Your Honor, without intervention by the court, if the parties are going to continue to be in close proximity of each other, she's going to continue to have this emotional distress. She's seeing a professional once a week to deal with this and to deal with the emotional distress that has been caused by the Beckers. And Your Honor, that's the that's the second factor for the court to consider. The third is there's no plain, speedy, and adequate remedy at law. The requested injunctive relief is the only adequate remedy, as the Becker's behavior to date indicates they will not behave civilly towards Ms. Geisler, but will continue to intercept her, harass her, and intimidate her with the intention to cause her irreparable emotional distress. Factor number 4, the granting of a preliminary injunction will not disserve the public interest. On the contrary, it will serve the public interest by preventing the Beckers from engaging in their continued behavior of harassing and menacing Ms. Geisler by following her, constantly video recording her. As anyone who openly brandishes a pistol on the inclined trail or hides in bushes video recording a female hiker that passes by, anyone in the community, I think, Your Honor, would find to be that disturbing. Factor 5, the balance of equities favors the requested injunction. Ms. Geisler should have peace of mind and should be able to train at the inclined trail like anybody else without the fear and anxiety of the Beckers stalking her, following her, hiding in the bushes to record her as she hikes. And certainly, she should be free from the fear of someone walking by and exposing a firearm within just a few feet of her. Ms. Geisler's request that the Beckers be ordered not to contact her and her husband and to maintain a 200-foot distance outside of this courthouse will help to mitigate her damages for intentional infliction of emotional distress. The burden imposed on the Beckers for the requested relief is minimal, and it simply requires that they behave like civil human beings. The Beckers would not be deprived from hiking the inclined trail. They're welcome to hike it just as Ms. Geisler is, but the Beckers would only be required to keep a 200-foot distance from Mrs. Geisler and her husband and refrain from communicating with them until a trial on the merits. For these reasons, the requested injunction will preserve the status quo pending a trial on the merits. Now, admittedly, Ms. Geisler seeks an extraordinary remedy, a preliminary injunction, but only because she faces immediate and irreparable emotional distress every time she hikes the incline, multiple times each week. Ms. Geisler should not have to give up her passion and her commitment to continue to train at the incline and pursue additional records and goals just to avoid suffering further emotional distress from the Beckers' ongoing and collective harassment, intimidation, and stalking of her on and near the inclined trail. Lastly, to address the matter of bond, should the court grant the motion for preliminary injunction, it's plaintiff's position. Well, first, the applicable case law reflects that the amount of security required by Rule 65 is discretionary with the court so long as it bears a reasonable relationship to the potential costs and losses occasioned by a preliminary injunction, which is later determined to have been improperly granted. It's plaintiff's position that if this motion were granted, $100 is a reasonable bond amount. Reason being is given the Beckers would not incur any damages should the requested relief be granted pending a trial on the merits. Plaintiff only asks that the Beckers refrain from making any contact with her and her husband and maintain a distance of 200 feet from them unless attending a judicial proceeding. Those aren't quantifiable damages, Your Honor. They're not really being burdened with doing anything other than not communicating and maintaining a distance. So if this motion were granted, I feel the appropriate bond, and plaintiff's position is the appropriate bond, if it was found later that the preliminary injunction were improperly granted, would be nominal, $100. Plaintiff rests, Your Honor.
Thank you. Mr. Kane.
Isn't it interesting that when I read the court's ruling concerning the SLAPP statute, I thought the plaintiff lost. And I thought the plaintiff lost because the court declared that this is a public issue. When you do that, you got to kind of know what you're looking at. But then you got to go to the jury instructions that says for libel and slander, if it's an issue, if it's a public issue, they've got to prove actual malice on the part of the Beckers. And they actually knew that whatever statements they were making were false. That's one. The other thing is they have to prove actual damages. No reputation this time. You got to prove that you've been actually injured. And you said in making your declaration that it was a matter of public issue, that it's a higher standard now. They got to prove it. They've got to prove it. And so I suggest to the court that I don't think it is a probability that they're going to prevail on the merits, especially against the Beckers. Because in that case, they're reporting what other people reported to them. They're not doing any independent statements, none of that stuff. They're just saying what other people reported to them. Now that's fair. As far as all this advising and taking pictures and that kind of stuff, when El Paso County Sheriff says, the best thing to do here is for you to take video and to protect yourself. That's what's going on. I told him the same thing. If you're going to seize them on the trail.
Well, no, I let that evidence in, Mr. Kane, but it seems to me you are on dangerous territory when you stand there and tell me that you gave clients advice and they followed it. Doesn't that introduce a component into the case that likely results in your being a witness?
I will withdraw the statement.
All right.
I will withdraw the statement. I will say that they were advised by law enforcement to take video, and they did that. But I'll withdraw that statement. As far as credibility goes, let's look at the statements made first in the press conference that I think is part of the record in this case, and then second at the transcript from the previous matter concerning a permanent restraining order. At that time, it was represented to the court, I'm all done with the incline, I'm not going back. And she went back. And so there's a credibility issue here as well, Judge, that I think needs to be looked at pretty carefully. There has been nothing but a denial by my clients that they meant to do anything but just take videos. There's nothing in the record that anything happened other than taking pictures. That's it. The fact that he carries a pistol is totally lawful. He can do that if he wants. He never drew it. He never threatened anybody with it. There's no intention. There's no evidence to that along those lines. I would imagine there's more than one pistol going up and down the incline. But that's just, I guess, for another day. As far as the public interest is concerned, I have some real question as to how the public interest is served or not served by issuing a restraining order in this case. I don't think the public interest is served. I think it's contrary to his burden. I don't think he's made his burden. There's no evidence of brandishing. There's no evidence of physical threats. There's no evidence of verbal threats. There's no evidence that anything happened other than she gets within the immediate neighborhood and they're photographed. That's it. That's it. All of this is a result of litigation that they filed. And my clients, I think, are entitled to gather evidence to their benefit if such evidence exists. They were doing what they were told. There's no indication of any threat. There's no indication of significant bodily injury. And I think that's what we're talking about here. And I think also we have to look at how much of this is self-inflicted and how much is a probable response to the conduct of the Beckers. They're just taking videos of people out in the public. That's all they're doing. And they're not making any threatening gestures. The court's seen the videos and he's seen the postures that are shown in exhibits 5-4, 5-5 in there someplace. They haven't met their burden. There is no immediate danger. And this request should be denied.
Let me organize a ruling and we'll be back in 5 minutes. We'll be in recess.
All rise, please.
All right, time for me to show my incompetence. This is the second break that I told you I didn't edit out. So just hold on, I'm gonna find it. He was gone for a bit. There he is. All right, we're just gonna have to play a few minutes of silence. I hear what you guys are saying in chat, and I don't know if I'm on the same side. I just don't know. But we'll listen to the judge. Let's listen to the judge in a minute. I'll just say this while we're waiting. I'll just say this one thing. The only reason why they're taking pictures of her is because when they tried to serve papers to her, she called the police on them and told the police that he was following her with a gun or whatever. That's why they're doing it.
Is called to order. We are back in session. I've taken the last few minutes to review the evidence in the case and the applicable law and rules. As correctly identified by plaintiff's counsel, the factors that are set forth in determining whether a preliminary injunction should be granted are set forth in the Supreme Court's decision, Colorado Supreme Court's decision in Rathke versus McFarland at 648 Pacific 2nd, 648 pages 653 through 654. And my ruling is based on that, as well as the Rule 65 of the Colorado Rules of Civil Procedure. In making the ruling, the issue presented is whether or not the plaintiff has proven by a preponderance of the evidence at this point each of the 6 factors that are set out. And I should say they're not factors, they're requirements. And the 6 requirements are as follows. First, is there a reasonable probability of success on the merits? In this case, the plaintiff has initiated a lawsuit with three claims: defamation per se, intentional infliction of emotional distress, and civil conspiracy. The requirement under Rathke versus McFarland is that the plaintiff demonstrate that there is a reasonable probability of success on the merits of those claims. On the merits of those claims, I have received very, very, very little evidence today. The fact that I have ruled previously with regard to motions to dismiss and a motion related to the statute concerning strategic litigation is not persuasive. Those standards are much different than the standard applied today. The standard to be applied today is whether or not the plaintiff has proven a reasonable probability of success on the 3 claims set out in her lawsuit. And I conclude she has not. There is not a reasonable probability of success on the merits of the lawsuit with the evidence that I have before me as of the hearing today. The second factor is whether there is danger of real, immediate, and irreparable injury that could be prevented by injunctive relief. I have considered the effect of the recordings that are at issue and the other conduct alleged in determining whether this is real, immediate, or irreparable injury that could be prevented by injunctive relief. And I find that there is not a danger of real, immediate, and irreparable injury by the continuing conduct of the defendants in this case. It is true with regard to the third factor that there is no plain, speedy, and adequate remedy at law. That is true. The plaintiff has demonstrated that. The fourth factor is whether the granting of a preliminary injunction will disserve the public interest. And I do find that the granting of a preliminary injunction in this case would disserve the public interest. The public interest in this case is affording a defendant the opportunity to collect evidence that would assist the court and the jury in determining what the facts are. In this case, the evidence that I have as of today is that the recording and allegations of stalking and harassment were initiated by the defendants after the advice that they received from law enforcement to document their interactions with the plaintiff. Allegedly, after false claims made by the plaintiff to the police about the brandishing of a firearm during the attempted service of process. So, to prevent the defendants from collecting evidence with regard to contacts with the plaintiff would disserve the public interest and frustrate the ability of the defendants to protect themselves against further claims by the plaintiff. The fifth factor is whether the balance of equities favors the injunction, and I find the balance of equities does not favor the injunction. As I've indicated, the balance of equities here, at least at this point, based on the evidence I've received as of today, is with the defense. The defense initiated the conduct that is the subject of the injunction only after the allegedly false claim to the police that the defendant was brandishing a weapon during the attempted service. Additionally, I will note that the requested injunction would prohibit the defendants from using the incline or being around the incline, which is in their own backyard, versus the plaintiff who has to travel some distance to go to this site. The sixth factor is whether the injunction would preserve the status quo pending a trial on the merits. It would not. The status quo is both parties continue to use the incline. The recording does not interfere with obviously not interfere with the plaintiff's use of the incline with the number of times she's used the incline over the last several months. So for all those reasons, let me address one other issue before we go any further, and that is as I understand, brandishment of a weapon. Brandishment of a weapon means pulling it out of the holster, waving it around, or using the weapon physically in a way that is intended to threaten or intimidate someone else. There has been absolutely no credible evidence of this. The one incident that I've been asked to consider is the exposing the weapon when the hoodie was pulled up. In that regard, I find the testimony of defendant Trevor Becker and the testimony of Mr. Gessler to be credible, and the testimony of Chastity Gessler on this issue to be unbelievable and incredible. So for all those reasons, the motion for preliminary injunction is denied. Additionally, one other factor in concluding that the carrying of the weapon by Mr. Trevor Becker is not intended as a threatening activity, I'll note that the plaintiff has introduced Exhibit 6.3, which appears to be something along the lines of a Christmas card photograph, that even in that picture has Mr. Trevor Becker carrying his weapon, which is strong proof to me that his carrying the weapon on the incline is his normal practice and has nothing to do with threatening the plaintiff. The findings made at a preliminary injunction hearing are preliminary. And based on the evidence that I have in front of me as of today, I recognize that that evidence may develop further as we move the case along. So what are we doing to move the case along? Mr. Mitchell, have you set a case management conference?
I don't have that information in front of me, Your Honor, but I believe we have.
Okay, let me check.
I don't have a specific date if we have, but I can confirm that when I return to the office.
What's the status of that? I'm not seeing one.
Yeah, Your Honor, we had filed a case management order based on an at-issue date that prior to rulings on my motions. So we would need to file a new case management order. And the court's order was that the case management conference that we had previously set was premature. And I don't believe it was ever reset. So I'd asked for a DPO for the plaintiff to notice up a new case management conference and for the attorneys to submit an updated case management order.
Is that something we could do when everybody's here today, or do we need to wait?
We're here.
Right.
Yeah, we're here too.
Available dates for CMC?
Call current.
When would you all be ready? Well, I guess let me back up. When do we want to do it? April 15th at 8:30.
So there's 3 more minutes, and all they're doing is talking about an administrative court maintenance meeting that's next. And I'm going to be perfectly honest with y'all. I have no idea what that means. I think that this part of this case is done. There's no more. There's no trial or anything going to be next. I don't think. I don't know, because some of that stuff that they said at the end was a little confusing. But again, there's more than one case. There's more than one lawsuit that she has. So here's what I think. I think when Trevor said that the police told him to crouch and make yourself as small as possible or whatever, unintimidating, I think that's a lie. I just do. I think that he exaggerated what the police actually said, which was, if you get in contact with them, film it. I believe the police said that because that's just smart. The way he's filming it while hiding in bushes and stuff, yeah, that's a little bad. But from what I understand, I just feel like she brought it on herself by doing a whole bunch of different things. I don't know what's happening with all the other lawsuits. I don't know why they were dropped, but she doesn't sound like the most pleasant person in the world to deal with, especially when his freedom was at risk. Like when she called the police on him for pulling a gun out on her, and I don't believe he did. I don't believe that he had the video. We did not see the video, but they saw the video. We watched them see the video, and there was no gun. He was holding the process papers. He was holding the cell phone. She called the police and said that he was running after her with a gun. That's just a lie. It was just a lie. But thank you, Caroline. So, you F around and you find out sometimes that, when you do that to people, they're going to record you. That way you can't lie about them again. Man, I can't believe that my stream is ending. I know this was a long stream, but I'm usually way in the future. It's only 12 a.m. and I'm done. Thanks, Cha. Oh, guys, thank you so much for sticking with me for this really, really long stream. There are still like 40 people on. Whew. I think he was probably told to avoid her, or if he couldn't, then step aside and record. And that makes sense too. You know, if you're on the trail, the police probably said, yeah, step aside. But I doubt they said hide in bushes and creep down real low and make yourself look small. Oh gosh, Chad, go watch The Voice. Go, go, go. See ya. But yeah, I don't. Yeah, the attorney probably said the other stuff. I don't know. I can't imagine any grown adult telling a man to crouch down real low when someone's walking beside them on a trail. I mean, bears, yeah. You know, mountain lions, okay. I think though I'm wrong on there. I think I'm way wrong. I think when you run into a bear, you're supposed to make yourself look really big, which is why I eat a lot, because I want a bear to know that I'm very big. No, I'm not. I'm not. Oh my. But whatever. Well, the wife got involved because um like she record it's right by their house, and Beatrice, or whatever her name was, would start recording her home, her on her in her home. So the wife started recording back, because so what they were doing is legal. You're allowed to record anything in public. You're allowed to. It's the law. But you can't record someone in their home. That's not, that's not okay. That's stalking behavior. So the case should have been the other way around. She should have been brought up in charges for filming in her house. Well, no. Okay, so Kelly's saying in chat, if you can't see chat, that the wife was in that parking lot and filming her. If I had a husband and some woman called the police on my husband saying that he was brandishing a gun, and I know that she's a liar, and I know that she's trying to get my husband, and I would definitely film her too, and I definitely wouldn't step out of the way, and I definitely wouldn't be as nice as these people are. There's no way. They called insults out to him as he's walking. No. I would be the one calling insults out, because that's legal. You can say whatever you want to somebody. I would never, be polite about someone like that, ever. Ever. That woman would not come back to the trail anymore just because of me. Then I would be harassing, but that's okay. But yeah. Oh man. I still want to know what happened yesterday. I want to know what happened to that guy who was sent to prison, or who was about to be sent to prison, and the perpetrator of a crime against his daughter was there. I know he doesn't go in yet, not till March. And I know we're never going to find out what happens, ever. But I'm dying to know what's going on there. Oh well, you know what I'm going to do? I'm going to get some sleep tonight. Isn't that crazy? Maybe. I don't know. My cat just had one kitten. Just one. So I might just play with that one kitten for a bit. Well, guys, thank you so much. This wraps up my weekend. Tomorrow's Wednesday, so I have to go back to work tomorrow. Blah. Yeah, I think we can figure it out too, Kelly. I know what I would do. Oh, man. I did. Okay. All right. I did name the kitten. Here's how I named it. So there was this show on HBO called True Blood. A lot of you probably seen it. So my cat got really big. So I thought, oh my gosh, she's going to have a load of kittens. So I had Lafayette, Elsie, Jason, Eric, and Sookie picked out for these kittens. And then she pops out one kitten. So I had to pick my favorite. So obviously it's Lafayette. So now I have a Lafayette kitten running around my house. And my kids, they've never even seen the show. So they didn't understand why the cat's named Lafayette. But I do. And every time I say Lafayette, I smile a bit. Yeah, one kitten. One kitten. Oh well. One kitten is better than 0 kittens. That's just facts. All right, guys. Thank you so much for coming out. You guys have a great night. I had so much fun tonight. And I will see